Hi, this is Dale Mitchell, and we're here to present on Hein versus Freedom from Religion Foundation. This case was argued before the Supreme Court of the United States in 2007. The defendant in this case is J.F. Hein, Director of White House Office of Faith-Based and Community. J.F. Hein was appointed by President George Bush to be the director of WHOFBC, which aimed to help religious organizations across the country. The White House felt that these religious organizations were marginalized and were not being given the same amount of respect or opportunity for funding that secular organizations were receiving. J.F. Hein promptly left the White House after the lawsuit to go and head Baylor University's religious programs, and he's still there to this day. Now to look at our plaintiff. The Freedom from Religion Foundation was founded in 1976. And their goal is to complete the separation of church and state. They don't believe that we've gone far enough to separate church and state, and they're willing to do anything to reach those ends. Their primary goal, and to do that, is through lawsuits. They fund and provide lawyers for lawsuits and against anything religious, anything from public to private sector. If it involves religion and where they believe religion has overstepped its bounds, which would be all the time, then they are willing to sue for it. Their goal is to represent atheists, agnostics, and lapsed clergy. The first court this case went to was the District Court of Western Wisconsin, where J.F. Hein and the Department of Justice and the White House won. And the Freedom from Religion was told they did not have a case. They appealed this and went to the Seventh Circuit Court of Appeals, where the case was overturned and the court ruled that the Freedom from Religion Foundation did have a case and that taxpayer dollars could not be used in the ways they were using. Finally, the writ of certiorari was applied, and this case went to the Supreme Court, where in a 5-4 decision, the Supreme Court overruled the Seventh Circuit Court and went along with the previous decision by the District Court of Western Wisconsin. The reason this is a taxpayer concern is the court was trying to decide whether taxpayer dollars could be used to fund religious organizations in general. And the issue with the Freedom of Religion Foundation and what they were targeting is whether non-faith individual taxpayers should be able to have a say in government spending on faith-based initiatives and whether it's even relevant. Fact number one is the WHOFBC was created to ensure that religious organizations could receive the appropriate funding and support that the White House believed their secular counterparts were receiving. Overall, the White House believed that secular organizations were receiving more funding, more support, and were just more popular in general than religious organizations, and that's why they were seeking to change that to the WHOFBC. Something interesting about this organization, though, within the White House is that no congressional authority specifically legislated and ever came up before Congress to make sure this organization was appropriate and funded through Congress. It was created with funds approved by Congress for the executive branch, however, not through Congress. Because of this, it was never put forth before who we elect as our voter, as voters who we elect. And therefore, we weren't being represented as voters. And that was the Freedom from Religion's argument about why the White House Office for Religious Affairs shouldn't exist. Basically, they also argued that it effectively promoted religious groups over secular groups. The Establishment Clause was very important to this case. The Establishment Clause is the First Amendment of the United States Constitution, which prohibits government-mandated religion in any capacity whatsoever. The Freedom from Religion Foundation believes the White House may more or less declared a state religion by hosting a Christian foundation, which goal was to provide other foundations with money and support. Basically, they violated the First Amendment, and that's what the Freedom from Religion Foundation was advocating. Now I'm going to hand it over to Mitchell, and he's going to take it from here.
Thank you, Dale. I appreciate that. That was some great insight and not only, a little bit of background on the case that we had, but also, the plaintiff and defendant that was set forth, as well as some facts and a brief explanation of the Establishment Clause. I want to bring us into the reasoning for the Establishment Clause. And the Freedom from Religion Foundation believed that having a faith-based office was in violation of that establishment clause. Now we look at the top left or right, and it says in the First Amendment of the U.S. Bill of Rights, it says, Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof. They stated that building a faith-based community incentives office with taxpayers' money was unconstitutional and a violation of the Establishment Clause. So the question we ask, and the question the court has to ask, especially the Supreme Court, is can taxpayers use the Establishment Clause to challenge the executive branch actions funded by general appropriations rather than by any specific congressional grant? And in that, they had to make a decision, and they decided in a 5-4 decision that the Freedom from Religion Foundation did not have a case to sue and reversed the previous court's decision. That previous court's decision was the same as it said in the District Court of Western Wisconsin, where, the defendant won, as well as when the defendant won in this case. So we see that taxpayers cannot challenge the executive branch using the Establishment Clause. In the court case, Hein versus Freedom from Religion Foundation, they used the Flast versus Cohen decision, which was back in 1968. And the court stated that in order to have a standing under the Flast decision, a taxpayer must not only challenge a policy on the basis of the Establishment Clause, but also bring the challenge against a congressional expenditure. So we look at that, and now we kind of have to dig into the rationale of why did this case get overturned? And, it was a plurality decision, meaning that the court does have different interpretations of the law. So that means that, as you can see, it was a 5-4 decision. It was a very close decision that they had to make, and the plurality opinion was given by Altio. So now we're going into the rationale of why the court decided to overturn the previous court's decision. So we look at this and we say, the court said at least there's no congressional expenditure. So that's why they overturned it due to lack of standing. They said the Flast exception only covers congressional expenditures. Since this was an executive expenditure, it was funded by general appropriations. So the court said this did not violate the Establishment Clause, and the Flast decision was not applicable. The court said to extend the Flast decision to executive actions, this would threaten the separation of powers by relaxing the doctrine of standing and turning federal courts into general compliant bureaus. Now, this basically means that if the court would have agreed with Freedom from Religion Foundation, it would have had set a precedent that anybody could challenge the executive branch based on with the Establishment Clause based on anything, basically. It would have been a broad interpretation of the law. And that's why we agree with the court's decision that they had to set and a very strict interpretation of the law, which they applied here. And we believe this is very important because this is the future of the laws moving forward. And we don't want, another case to come abide and be prohibited by maybe a mistake that this court could have made. So moving on, we look at how it was compared to the Warner case with the Warner versus Boca Raton. And, these cases are pretty similar in the sense that they both use the First Amendment. The Warner case uses the Free Exercise Clause when the Hein versus Freedom from Religion Foundation uses the Establishment Clause. So in that, we see that there's restriction on government land versus the taxpayers' money to make a religious office. So the Warner case, the Warner family wanted to put a memorial that stayed above the ground. And they stated this was a religious act. With a federal judge, Judge Ramskin, ruled that displaying vertical memorials was not a religious act. both of these interpretations are very strict and narrow under the First Amendment. The Hein decision set a precedent to all that may challenge the executive branch under the Establishment Clause. We believe that's very important again, because if it wasn't challenged, then the precedent wouldn't be set. And because of the precedent set, we know that moving forward, there's going to be a strict interpretation of the law, meaning that the people wouldn't be able to sue just for anything of lack of standing, basically. And moving on, we have our works cited page, and me and Dale, thank you for watching our presentation.